We always find that the same questions are asked by people looking to file for a divorce. Some misconceptions too. We will cover some of these questions. How long do I need to be separated for before I get divorced? Generally, you need to be separated from your partner for a minimum of 12 months before you can apply for a divorce. If you reconciled with your partner for more than 3 months, then the 12-month period begins again. Does divorce deal with property and children matters? Many people mistake divorce to mean the whole matter of separation. Divorce proceedings do not finalize any arrangements regarding parenting and property. These types of orders need to be filed on a separate application. There are 3 stages of divorce and they are handled separately. 1. Divorce. 2. Financial, property settlement, and 3. Parenting arrangements. Can I still file for a divorce if my spouse doesn't agree? A divorce application does not require consent by both parties. As long as you fit the criteria to apply, one party may initiate the divorce proceedings. Can we get divorced in Australia if we got married overseas? Yes, if you were married overseas, you can apply for a divorce in Australia if either you or your spouse 1. Regard Australia as your home and intend to live indefinitely in Australia, are an Australian citizen or resident. 2. Are an Australia citizen by birth or descent. 3. Are an Australia citizen by grant of an Australia citizenship, or 4. Ordinarily live in Australia and have done so for 12 months immediately before filing for divorce. You must provide the court with a copy of your marriage certificate. If your marriage certificate is not in English, you need to file an English translation of it using a NATI accredited interpreter. How long do we have to wait to divide our assets? Your assets should be divided as soon as possible after separation. You do not have to wait until your divorce is final to complete this. If you are in a de facto relationship, you have 2 years from the date of separation to divide assets, or if you were married, you have 1 year from the date of your divorce grant. It is common practice to separate your assets first, before applying for a divorce order. Read more under our Property and Financial Settlement page. Can my child decide who they live with? In Australia, there is no minimum age for a child to be able to express their view about where they would like to live in a parenting dispute. The courts, as with all family dispute cases involving children, will look at the best interest of the child. Under Section 60cc(3) of the Family Law Act, there are 16 factors the court must consider when deciding what parenting arrangement is in the child's best interest. What happens to my business during divorce? Any interest in a business or company can be considered property in a divorce or property settlement. It does not matter what business structure is used. It doesn't matter whether the business is a partnership, sole trader or company. An asset is an asset, and as such, this interest must be valued to form part of the property pool. You should ensure you are aware of the business's business structure and control, as it will dictate how the company will be dealt with in separation. For this reason, it is vital to keep up-to-date and accurate records. Am I entitled to half of my ex's business? No, divorce or separation does not automatically mean the other party is entitled to half of the business. Instead, the value of the business is included in the party's property pool. Each party's entitlement to the business is determined following family law principles after the business has been valued. How do I apply for an intervention order? You are required to fill in the application form by going to a magistrate's court or by getting the form from the Magistrates Court Family Violence website. Once your application is submitted, you will be interviewed by a court registrar who will ask you about details of the events that have occurred, including dates, times and places. Be prepared to tell the registrar about personal information and provide evidence to support why you need the intervention order. What happens after applying for an intervention order? After your interview with the registrar, they will type up your application. Check that all of the details are correct and the conditions you'd like are accurate. If you agree with the application, you will be asked to sign it. The registrar will give you a copy of your application and a summons that tells you when the court date is. The police will receive a copy of these documents to serve on the respondent. An interim intervention order starts when the police give them a copy of the order. Thank you for listening to our podcast, and we hope you have found our questions and answers helpful. If there is anything further you would like to know, comment below and we will endeavour to answer them as soon as we can. Family Lawyers of Melbourne. We are here every step of the way. Call us today.